No one could have anticipated Supreme Court Justice Amy Coney Barrett directly addressing Keanu Reeves during the high-profile legal proceeding. The courtroom descended into complete silence as she gestured toward the beloved actor and philanthropist, her voice carrying unmistakable authority. "Mr. Reeves, your pattern of behavior demonstrates a consistent disregard for established judicial precedent," she proclaimed with resolute conviction. But what transpired next left the entire judicial panel utterly astonished. Keanu Reeves didn't shrink back. He didn't waver for even a moment. Instead, with characteristic calm, he simply opened a leather portfolio that would completely transform the trajectory of the case. The legal confrontation that was intended to humble one of Hollywood's most respected actors was about to backfire in the most spectacular fashion imaginable. Have you ever witnessed someone completely overturn expectations in a high-pressure situation? What does it take to maintain composure when facing such powerful opposition? If you want to witness true intellectual brilliance in action, watch this entire video and remember to like and subscribe for more extraordinary confrontations that mainstream media outlets refuse to cover. The stakes couldn't possibly have been higher. The case, Motion Picture Association vs. Arch Foundation, had finally reached the Supreme Court after months of escalating tensions and media speculation. At the heart of the dispute was whether Reeves' charitable organization had violated federal communications regulations by refusing to implement certain content filtering protocols on its educational platform. Justice Barrett, appointed by former President Trump and renowned for her brilliant legal mind and incisive questioning, had established herself as one of the most formidable intellectual forces on the bench. With her remarkable analytical abilities and unwavering commitment to legal precision, she had earned respect across ideological lines, even from those who frequently disagreed with her judicial philosophy. Keanu Reeves sat at the respondent's table dressed in a conservative charcoal suit with a simple black tie, the understated elegance that had become his signature rather than flashy Hollywood attire. His legal team surrounded him, but unlike most defendants who rely entirely on their attorneys to speak on their behalf, Reeves had made the unusual request to address the court personally, a decision many legal commentators had labeled dangerously presumptuous and potentially catastrophic. What drives people to stand up personally for their principles rather than delegating to specialists? Is there something particularly powerful about facing challenges directly? The government's position appeared unassailable. For months, media outlets had been reporting extensively on how the Arch Foundation had supposedly flagrantly disregarded established communication regulations. Legal analysts frequently appeared on news programs predicting Reeves would face devastating penalties and restrictions. The MPA had compiled what seemed like an impenetrable case, with extensive documentation showing alleged patterns of non-compliance. This case transcends mere regulatory technicalities, the Solicitor General had emphasized during her opening statement. This fundamentally addresses whether private organizations, regardless of their cultural significance or the popularity of their founders, must adhere to the same regulatory framework as all other entities. What nobody realized was that Keanu Reeves had been methodically preparing for this confrontation for nearly 14 months, immersing himself deeply in constitutional jurisprudence and legal precedent in a manner that would soon astonish the entire legal establishment. Justice Barrett began her questioning with characteristic precision. The courtroom was filled beyond capacity with journalists, constitutional scholars, and fortunate spectators who had secured seats for what had become the most closely watched Supreme Court case in recent memory. Law students in the gallery scribbled notes furiously, their expressions a mixture of anticipation and awe at witnessing such a high-profile confrontation. "Mr. Reeves, your foundation has repeatedly ignored formal directives to comply with Section 214 modifications outlined in the 2023 Digital Communications Act," Barrett stated, her tone measured but unmistakably stern. "Would you please explain why you believe your organization somehow deserves exemption from requirements that every other digital platform must follow?" Reeves leaned slightly toward the microphone. With profound respect, Justice Barrett, that characterization isn't entirely accurate. We've never claimed exemption from legitimate legislation." Barrett raised an eyebrow skeptically. "Your actions strongly suggest otherwise. You've received 23 formal notifications." 22, Reeves corrected calmly. The justice's expression tightened perceptibly. "Excuse me. There were 22 notifications, not 23, and we responded to each with detailed legal rationales grounded in established constitutional precedent." Barrett shuffled through the papers before her. "The official record indicates." "The record provided by the MPA is incomplete," Reeves interjected politely but firmly, something rarely done when addressing a Supreme Court justice. Audible gasps rippled through the courtroom. A young law clerk dropped his pen, the soft clatter echoing in the suddenly silent chamber. Chief Justice Roberts appeared ready to intervene, but Barrett subtly raised her hand, indicating she would manage the exchange. Her eyes narrowed slightly. "Mr. Reeves, this court has minimal patience for technical corrections that fail to address the substantive issue at hand. Your pattern of regulatory non-compliance is actually a pattern of constitutional adherence," Reeves concluded, opening the portfolio resting before him. The sunlight streaming through the high courtroom windows illuminated the pages as he carefully extracted a document marked with precise red highlights. "And I believe the court would benefit from reviewing evidence demonstrating that the MPA has deliberately mischaracterized our position." The tension in the chamber was palpable. Justice Sotomayor exchanged meaningful glances with Justice Jackson. Justice Gorsuch leaned forward with visible interest. Reporters in the gallery instinctively shifted to the edges of their seats, dozens of pens poised above notepads, sensing that history was unfolding before their eyes. When is challenging authority justified, and where is the line between respectful disagreement and disrespect? How do we maintain proper institutional respect while standing firm for our principles? Barrett's voice took on an edge rarely heard from the bench. "Mr. Reeves, this court has thoroughly reviewed the submitted briefs. Are you suggesting the justices have somehow overlooked critical information?" "Not at all," Reeves replied with characteristic humility. "I'm suggesting information was deliberately withheld from this court by the petitioners." The Deputy Solicitor General immediately rose to her feet. "Your Honors, this is an outrageous allegation entirely without foundation." Justice Barrett's voice cut decisively through the chamber. "Mr. Reeves, these are extraordinarily serious claims. Without substantial supporting evidence, making such allegations before this court could significantly undermine your credibility in this proceeding." Reeves remained perfectly composed. "I understand the gravity completely, Justice Barrett, which is precisely why I've brought documented evidence that the MPA's regulatory demands themselves violate 3 separate Supreme Court precedents, including one where you personally wrote the majority opinion." Barrett's expression remained impassive, but those familiar with her mannerisms could detect the slightest indication of surprise. She removed her glasses and looked directly at Reeves, who stood motionless, illuminated by the sunlight filtering through the courthouse dome. The courtroom was absolutely still, but history was already shifting beneath their feet. "Which opinion might that be?" Barrett asked, her voice slightly softer now. "Digital Frontiers vs. Harrington, 2024, where you specifically articulated that government agencies cannot compel private platforms to adopt content policies that effectively function as government speech controls through regulatory intermediaries." The courtroom fell absolutely silent. One law clerk whispered, "This is unprecedented," to a colleague. Even the court stenographer momentarily looked up from her machine, startled by the unexpected turn. This was clearly not the response anyone had anticipated. Justice Thomas, who had been quietly observing the proceedings, spoke up. "Mr. Reeves, are you asserting that the MPA directives fall within that prohibited category?" "Yes, Justice Thomas, and I've prepared a comprehensive analysis demonstrating precisely how." The MPA's senior counsel stood again. Your Honors, Mr. Reeves is not a legal expert. His interpretation of Justice Barrett's opinion is fundamentally flawed and self-serving. Barrett, however, was already reviewing the documents Reeves' team had submitted to the court clerk. Her expression remained unreadable, but she was clearly examining the material with intense concentration. Does the petitioner wish to contest the authenticity of these communications? She asked, looking directly at the MPA's counsel. The lawyer hesitated visibly. We would require time to properly examine what's been presented. Justice Barrett then did something unexpected. She turned back to Reeves. You arrived prepared specifically for this line of questioning. It wasn't phrased as a question, but Reeves answered nonetheless. I did, because the constitutional principles at stake extend far beyond my foundation. This case fundamentally addresses whether government agencies can exploit regulatory authority to accomplish what they are constitutionally prohibited from doing directly. How often do we allow administrative convenience to override fundamental principles? At what point should we draw the line, regardless of personal cost? The atmosphere in the courtroom had undergone a complete transformation. What began as what many expected to be a public rebuke of a defiant celebrity had evolved into something far more substantive, a serious constitutional challenge that no one had anticipated. Justice Barrett, known for her thoroughness, continued pressing, even accepting your premise regarding the MPA's motivations, your foundation still disregarded legally issued directives while you prepared this challenge. That's not how our constitutional system functions, Mr. Reeves. Reeves' response came without hesitation. Actually, Justice Barrett, in Youngstown Sheet and Tube Company v. Sawyer, this court established that when confronting potentially unconstitutional government directives, parties may seek judicial review prior to compliance when irreparable harm would result. We filed for emergency stays in 3 separate circuits while preparing our comprehensive response. Justice Barrett's eyes narrowed slightly, clearly reassessing the man standing before her. This wasn't merely an actor playing at constitutional law. Reeves had evidently conducted exhaustive research. Those emergency stays were denied, she noted pointedly. By split decisions, yes, Reeves acknowledged, but as Justice Jackson wrote in her dissent in the D.C. Circuit case, the constitutional questions raised were substantial and deserved full Supreme Court consideration. Justice Jackson, hearing her own words quoted, raised her eyebrows slightly in evident surprise. The Solicitor General, sensing the shifting momentum, attempted to redirect, Your Honors, Mr. Reeves' legal theories don't alter the fundamental fact that the Arch Foundation has repeatedly violated clear regulatory requirements. Justice Barrett turned toward her. Counselor, the constitutional validity of those very requirements appears to be precisely what's at issue in this proceeding. She turned back to Reeves. Please continue with your argument, Mr. Reeves. What transpired next would be replayed on news networks and across social media platforms for weeks afterward. Keanu Reeves, standing before the highest court in the land, delivered a masterclass in constitutional jurisprudence that left even his most vocal critics stunned into silence. Justice Barrett, I'd like to direct the court's attention to page 42 of the supplementary materials provided, Reeves said, his voice steady and confident. These are internal MPA communications obtained through Freedom of Information Act requests that explicitly discuss strategies to circumvent the constraints imposed by the Digital Frontiers decision. Barrett reviewed the document, her expression growing increasingly serious. These appear to be authentic MPA memoranda. They are, Reeves confirmed. Note the highlighted section where Commissioner Richardson writes, and I quote, while Barrett's opinion restricts our direct authority over content moderation, the technical compliance regulations provide us an alternative pathway to achieve essentially the same outcome. A murmur spread throughout the courtroom. Several justices were now examining the documents with visible interest. A prominent constitutional law professor in the gallery frantically scribbled notes, his eyes wide with astonishment. Journalists' fingers flew across their keyboards, capturing every word of this unexpected constitutional showdown. Justice Barrett looked up, her gaze intensifying. "Madam Solicitor General, would you care to address these documents?" The government's lawyer appeared momentarily flustered. "Your Honor, without proper context, isolated communications can be misleading. The MPA's regulatory actions were taken in good faith to enforce legitimate public interest standards. The context is provided in the subsequent pages," Reeves interjected, including meeting minutes where officials explicitly discussed using technical compliance regulations as, and I'm quoting directly, "a useful pretext" to pressure platforms into adopting specific moderation policies this court had already deemed constitutionally problematic. Justice Barrett turned back to the Solicitor General. "Counselor, I would need to examine these specific documents, Your Honor. They were not included in the record from the lower courts. Because the MPA successfully moved to have them sealed," Reeves added. "We only obtained them 26 days ago through a separate FOIA lawsuit that concluded in the Ninth Circuit." Justice Alito spoke up. "Mr. Reeves, are you suggesting there was a deliberate attempt to conceal these communications from the courts?" "The evidence speaks for itself, Justice Alito. The MPA was aware these directives contradicted this court's ruling in Digital Frontiers. Rather than respect that precedent, they sought to circumvent it through technical regulations. How much of our institutional trust depends on good faith actors? What happens when regulatory bodies act strategically rather than transparently?" Justice Barrett was now fully engaged. Her initial skepticism had transformed into deep judicial interest. "Mr. Reeves, your legal argument extends beyond simply citing precedent. You're essentially claiming the MPA engaged in regulatory pretext to achieve unconstitutional ends." "Exactly, Justice Barrett," Reeves replied. "And not just any unconstitutional ends specifically prohibited by your opinion less than a year ago." The moment was powerful. Barrett, who had begun by challenging Reeves, was now visibly considering the substance of his argument with the seriousness it deserved. "Your Honor," Reeves continued, "I'm not an attorney by training, but I've invested thousands of hours studying constitutional law in preparation for this case because I recognized something fundamental was at stake. When I read your opinion in Digital Frontiers, I was struck by your clarity regarding government attempts to control speech through regulatory proxies." He then cited directly from Barrett's opinion, "When governmental power leverages regulatory authority to indirectly accomplish what the First Amendment explicitly forbids it from doing directly, courts must exercise exceptional vigilance." Those words guided our response to the MPA's directives. The courtroom remained completely silent as Barrett looked directly at Reeves, reassessing everything about the case before her. "The MPA's directives weren't genuinely about technical compliance," Reeves continued. "They were designed to pressure us into implementing specific content moderation practices that would restrict certain viewpoints. The internal documents conclusively demonstrate this was their intent from the beginning." Justice Barrett nodded slowly, then asked the question that would define the case, "Mr. Reeves, if your characterization is accurate, why has no other platform challenged these directives on constitutional grounds?" Reeves' answer was simple but powerful, because challenging the federal government requires resources and determination that most organizations simply don't possess. The path of least resistance is always compliance, even with potentially unconstitutional demands. I was fortunate enough to have both the resources and conviction to challenge what I perceived as regulatory overreach. Barrett looked down at her notes, then back at Reeves. Her tone had completely transformed from the beginning of the exchange. "Your legal reasoning is considerably more substantive than I initially anticipated, Mr. Reeves." Coming from Justice Barrett, known for her exacting standards, this represented extraordinary recognition. The Solicitor General made one final attempt to recover ground. "Your Honors, regardless of Mr. Reeves' legal theories, the fact remains that the Arch Foundation has refused to comply with legally issued directives while every other digital platform has managed to do so. Justice Barrett turned toward her, her expression now hardened with evident concern. "Madam Solicitor General, this court will require an immediate explanation as to why this material was concealed from the lower courts." Barrett paused. The Solicitor General froze, stammering incoherently. A long, painful silence followed. Even the court stenographer looked up from her machine. The spell of the government's certainty had shattered completely. When Barrett spoke again, her voice carried the weight of judicial authority. "Counselor, if these directives were indeed issued as pretext for unconstitutional ends, as Mr. Reeves suggests and these documents indicate, then widespread compliance isn't evidence of their legitimacy but rather of the chilling effect such regulatory power can exert on constitutional rights." The government's case was visibly collapsing before everyone's eyes. Several members of the MPA legal team whispered urgently to each other, papers shuffling frantically as they searched for a response that wasn't there. What had begun as a seemingly straightforward regulatory enforcement action had transformed into a landmark constitutional case examining government overreach. Barrett turned back to Reeves. "To be absolutely clear, Mr. Reeves, your position is that the Arch Foundation didn't refuse to comply with legitimate regulations but rather refused to submit to unconstitutional government pressure disguised as regulation." "Precisely, Justice Barrett," Reeves confirmed. His voice resonated through the chamber with quiet confidence. "We did not resist the law. We resisted the distortion of it. Sometimes, standing silent is compliance with injustice." A law student in the gallery audibly gasped. A veteran court reporter later described it as, "the moment the room collectively realized they were witnessing a watershed constitutional moment, not a celebrity being put in his place." Barrett nodded thoughtfully, then exchanged glances with her fellow justices. Something significant had clearly shifted in the courtroom. What everyone had expected to be a reprimand of a celebrity had become a serious examination of potential government overreach. What happens when our regulatory frameworks are used for purposes beyond their stated intentions? How do we maintain proper checks and balances? The Chief Justice spoke. "I believe we need to hear more about these documents. Madam Solicitor General, the court will expect a thorough explanation of these communications." The triumph wasn't merely that Reeves had maintained his position. It was that he had completely transformed the entire framework of the case through meticulous preparation and unexpected legal expertise. The Supreme Court took an unusual step 3 days later. Rather than waiting months for a decision, they issued an immediate administrative stay against all MPA enforcement actions related to the disputed directives. Legal analysts called it an extraordinary vindication of Reeves' position. CNN legal analyst Jeffrey Toobin appeared visibly stunned during a live broadcast. "What we witnessed was truly remarkable." Justice Barrett, who everyone expected would be Reeves' most formidable critic, essentially validated his core legal argument. "I've covered the court for decades, and I've never witnessed anything quite like it." The story exploded across all media platforms. Hashtags like #ReevesLegalGenius and #BarrettReevesShowdown trended for days. Social media users shared clips of the exchange that had been captured by court sketch artists and later animated by news networks. Former Supreme Court clerks dissected Reeves' arguments on legal podcasts, with many expressing astonishment at their sophistication. "He cited precedents I had to research, and I teach constitutional law," admitted Yale law professor Amanda Silverstein on her popular podcast. Justice Barrett herself maintained appropriate judicial silence regarding the ongoing case, but sources close to the court reported she had directed her clerks to conduct a comprehensive review of all MPA communications related to content moderation spanning back 3 years. The implications extended far beyond Reeves and the Arch Foundation. Other platforms began publicly questioning MPA directives they had previously accepted without challenge. Netflix announced it was reviewing compliance requirements in light of constitutional concerns raised in the Supreme Court. Disney's streaming division filed a motion to join Reeves' case as an interested party. Legal scholars began publishing analyses suggesting the case could become one of the most significant First Amendment decisions in decades. Harvard Law Review fast-tracked a special issue dedicated to the constitutional questions raised by the case. Meanwhile, the MPA faced mounting pressure. 3 commissioners were called to testify before Congress about the internal communications revealed in court. Documents released by the Arch Foundation demonstrated how extensively Reeves had prepared, accumulating over 600 pages of legal precedent and analysis before the hearing. A week after the hearing, a former MPA staff attorney came forward as a whistleblower, confirming there had indeed been an internal strategy to use technical regulations as leverage for content control. There were explicit discussions about using compliance measures as pressure points to force platforms to adopt moderation policies we couldn't legally mandate directly, she revealed in an interview. Justice Barrett found herself in an unexpected position, widely praised across the political spectrum for her intellectual honesty in engaging with Reeves' arguments despite what appeared to be her initial skepticism. Legal commentators noted how she had demonstrated the exact judicial temperament she had advocated during her confirmation hearings. In entertainment and philanthropy circles, Reeves' reputation transformed overnight. Beyond being viewed as a talented actor and generous philanthropist, he was now recognized as someone with serious legal acumen. Stanford Law School invited him to deliver a guest lecture on regulatory overreach and constitutional limitations. Is this case evidence that sometimes our assumptions about expertise can blind us to the capabilities of those outside traditional professional paths? What other areas might benefit from outsider perspectives? The case wasn't fully resolved. Oral arguments would continue, and a final decision remained months away, but the momentum had clearly shifted. Legal experts increasingly predicted a landmark ruling that would establish new boundaries on how government agencies could exercise regulatory authority when it intersected with First Amendment issues. During a press conference on the courthouse steps following the administrative stay announcement, a reporter asked Reeves about his surprising legal knowledge. "I'm not a lawyer," he responded with his characteristic humble smile. "But when fundamental principles are at stake, you make time to learn what you need to know." Justice Barrett's previous writings on government overreach actually served as my roadmap. I simply followed where her own legal reasoning naturally led. The reporter followed up, "Did you expect to change her mind?" "I didn't try to change anyone's mind," Reeves replied thoughtfully. "I simply presented evidence and constitutional arguments I believed were sound." Justice Barrett is renowned for her intellectual integrity. "All I did was take her previous legal reasoning seriously and apply it consistently to our situation." As legal scholars continued analyzing the case, many noted the irony. The government had hoped to make an example of Reeves by bringing the case to the Supreme Court, expecting Justice Barrett and others to deliver a harsh rebuke to what they characterized as celebrity exceptionalism. Instead, Reeves had effectively reversed the narrative, using Barrett's own judicial philosophy to expose what appeared to be genuine governmental overreach. Perhaps the most telling reaction came from an anonymous comment reportedly made by a Supreme Court clerk. "Everyone expected David versus Goliath with Reeves as Goliath. What we got was a masterclass in constitutional law from someone who wasn't even supposed to be taken seriously as a legal thinker." The case continued to develop, with legal experts predicting it would establish a crucial precedent for the digital age. All because one man decided to stand his ground and thoroughly prepare before facing one of the nation's most formidable legal minds. This wasn't just about Keanu Reeves anymore. It had evolved into a fundamental examination of the relationship between government power and free expression in the digital age. And it all began because a justice attempted to challenge an actor who turned out to understand her legal opinions better than almost anyone expected. In a world where celebrities are often dismissed as intellectually lightweight, What does this case teach us about judging people based on their public personas? How many other voices might we be dismissing simply because they come from unexpected quarters? In the weeks following the hearing, legal scholars began exploring the profound implications of what was now being called the Reeves doctrine, the idea that regulatory bodies cannot use technical compliance requirements as a backdoor method to achieve what would otherwise be constitutionally prohibited. Several law schools added the case to their constitutional law curriculum even before a final ruling. What made Reeves' legal strategy particularly effective was his decision to ground his arguments directly in Justice Barrett's own judicial philosophy. Rather than attacking her perspective, he embraced it, arguing essentially that he was simply following her constitutional reasoning to its logical conclusion. This approach made it exceptionally difficult for the government to dismiss his position without implicitly criticizing one of their strongest allies on the court. The case also sparked broader conversations about the role of non-lawyers in constitutional debates. Historically, the legal profession had maintained something of a guild mentality, suggesting that only those with formal legal training could meaningfully engage with complex constitutional questions. Reeves had dramatically challenged this assumption, demonstrating that dedicated study and intellectual honesty could sometimes overcome gaps in traditional credentials. What we're seeing is a democratization of constitutional discourse, noted Georgetown law professor Eleanor Michaels. Reeves has shown that with sufficient commitment, citizens can engage directly with fundamental questions about government power and individual rights without necessarily relying on professional intermediaries. This perspective resonated deeply with many Americans who had grown increasingly frustrated with what they perceived as a legal system accessible only to specialists. Reeves' performance suggested an alternative approach, one where determined citizens could develop the expertise necessary to challenge overreach directly. Does our society place too much emphasis on credentials rather than capability? How might we better recognize and utilize the talents and insights of those who take unconventional paths to expertise? As additional documents came to light through subsequent FOIA requests, it became increasingly clear that the MPA's regulatory approach had been coordinated with several other federal agencies, raising troubling questions about a potential whole-of-government strategy to control digital content through regulatory pressure rather than legislation. What we're potentially uncovering here is a deliberate attempt to accomplish through regulation what couldn't be achieved through legislative channels due to First Amendment constraints, explained constitutional scholar Jonathan Turley. If proven, this would represent precisely the sort of end run around constitutional limitations that the court has historically viewed with extreme skepticism. This broader context explained why the case had attracted such extraordinary attention. It wasn't merely about one foundation's resistance to regulatory requirements, it potentially represented a test case for the government's entire approach to digital content regulation. Justice Barrett found herself navigating delicate terrain. As the author of the Digital Frontiers opinion that Reeves had so effectively deployed, she faced the challenge of maintaining judicial consistency while potentially acknowledging that a government agency had attempted to circumvent her own reasoning. Legal observers noted the intellectual integrity she displayed in engaging seriously with arguments that effectively accused the government of attempting to undermine her previous ruling. In entertainment circles, Reeves' reputation underwent a fascinating evolution. Already respected for his professionalism, generosity, and humility, he now added an unexpected dimension, that of a serious constitutional thinker. Several major publications ran profiles attempting to understand how an actor had developed such sophisticated legal understanding. "I've always been interested in philosophy and ethics," Reeves explained in a rare extended interview. "When this case emerged, I recognized it touched on fundamental questions about the relationship between citizens and government. So I simply started reading, beginning with Justice Barrett's brilliant analysis in Digital Frontiers and working outward from there." His approach revealed something important, that complex legal concepts, when stripped of unnecessary jargon and approached with genuine intellectual curiosity, could be accessible to dedicated non-specialists. This realization threatened to undermine the mystique that sometimes surrounded constitutional interpretation. The case wasn't fully resolved. Oral arguments would continue, and a final decision remained months away, but the trajectory had clearly changed. What had begun as a straightforward regulatory enforcement action had evolved into a potential landmark case on government overreach and First Amendment protections. During the courthouse press conference, a reporter asked Reeves about his surprising legal acumen. "I don't consider myself a legal expert," he responded thoughtfully. "But when fundamental principles are at stake, you find the time to learn what's necessary." Justice Barrett's previous writings on regulatory overreach actually served as my roadmap. I simply followed where her own legal reasoning naturally led. The reporter pressed further, "Did you expect to change her perspective?" "I never attempted to change anyone's mind," Reeves replied. "I simply presented evidence and constitutional arguments I believed were sound." Justice Barrett is known for her intellectual integrity. "All I did was take her previous legal reasoning seriously and apply it consistently to our situation." As legal scholars continued analyzing the case, many observed the irony. The government had hoped to make an example of Reeves by bringing the case to the Supreme Court, expecting Justice Barrett and others to deliver a firm rebuke to what they characterized as celebrity exceptionalism. Instead, Reeves had effectively turned the tables, using Barrett's own judicial philosophy to expose what appeared to be genuine governmental overreach. In his final statement before leaving the courthouse that day, Reeves delivered a line that would be quoted in law schools for years to come: "Justice is not reserved for those with degrees. It's for those with the courage to ask if the rules serve the people, or simply the powerful." The implications reached far beyond this single case. Other regulatory agencies began reviewing their enforcement approaches, concerned about potential constitutional vulnerabilities that might be exposed under the heightened scrutiny Reeves had helped trigger. Several pending regulations were quietly withdrawn for further review, suggesting a broader reassessment of the government's regulatory strategy. Meanwhile, public interest in constitutional issues surged. Law schools reported increased applications to constitutional law programs, and online courses on the First Amendment saw enrollment skyrocket. Many cited Reeves' example as inspiration. The idea that ordinary citizens could meaningfully engage with complex constitutional questions resonated powerfully. What Reeves demonstrated wasn't just legal acumen, noted Harvard constitutional scholar Lawrence Tribe. He showed that passionate citizenship sometimes requires developing expertise outside our comfort zones. That's a profound lesson for a democracy. The case continued to unfold, with potentially far-reaching implications for both government regulation and individual rights. And it all began with a seemingly routine regulatory action that unexpectedly encountered a non-lawyer who had done his constitutional homework. In a world of increasing regulatory complexity, what responsibility do citizens have to understand the constitutional foundations of our system? Can passionate amateurs sometimes see connections that specialists miss? If this video opened your eyes to how the system really operates, don't forget to like, share, and subscribe. We bring you the authentic stories mainstream media outlets refuse to cover, the confrontations that fundamentally change everything. Hit that notification bell to ensure you never miss the truth about what's really happening in America today. Do you believe ordinary citizens should play a more active role in holding power accountable, or should we always defer to the experts? Comment 1 for active citizen engagement, or 2 for trust the professionals.